Welcome to another webcast-only episode of John Redmann Power of Attorney. Today our Lagniappe section is on divorce, and our special guest is Stacey Williams Marcel, or Stacey Marcel Williams, excuse me, an attorney with many years' experience handling divorce cases, also mediating divorce cases as a certified mediator. We had an excellent show on broadcast television. This Lagniappe section goes into a little more detail on a couple of topics we just didn't have time to get to on the show. So let's get right to it. Stacey, a common question is, after someone gets a divorce, the wife who gets a divorce, she wants to know, and someone wrote in, what happens to my maiden name? Can I use it again? What's the answer to that?
Usually if people want to revert to using their maiden name, I put that as part of the divorce judgment. If you want to keep your married name, you don't put it in the divorce judgment. I think most people don't realize that you always can use your maiden name. Sometimes, though, I think the complication comes with credit cards or other documents, and they want a legal document saying your name was changed or that type of thing.
Right.
But you can also go to the district attorney and file a name change, but usually I put it in the divorce judgment.
Okay, but legally, you already have the right to use your last name, even when you're still married. And certainly after your divorce, you can just start using your last name. You might need to show your divorce judgment to the Department of Motor Vehicles if you want it to be reflected on your driver's license, correct?
Correct.
Okay, great. Moving right along, because we're trying to cover a lot of ground here. A very important topic, and that is what happens when one of the two spouses comes to a divorce attorney such as yourself and says, we want to get one of those no-fault divorces that says you've been living separate and apart for 365 days or 180 days, and wink, wink, nudge, nudge, my ex and I, we agreed that we're willing to sign on that affidavit or sign wherever we got to sign or hold up our hand and swear that we've already been living apart all that time. We're just so sick of each other, we want to get this thing done with. What advice do you have for those people?
First of all, I won't handle the divorce, and let me tell you why. Because first of all, you're signing an affidavit and you're not telling the truth, and that can get you in trouble with the court.
And now that you're the attorney, and now that they've let you know it's not the truth, that
right.
puts you in an ethical conflict.
And even if you don't tell the attorney and try and pass it off, let me tell you what can happen. What happens when farther down the line you have a dispute with your ex-spouse, and they say, well, I'm going to go back to the court and tell them we didn't live apart. And under the law, if you did not live apart the amount of time that's required, it is an absolute nullity, which will create a mess, because then you have to start over, file a divorce.
Never
then you
mind
have property
that you lied
issues
to the court, which
exactly.
can be a really big mess.
Exactly.
Criminal prosecutions, possibly. You don't want to go that route.
You know, I tell people it may seem like a period of time, but it's better to do things right and be truthful.
Absolutely. And on that note, you know, you can say, well, it's going to be his word against mine. Well, no, honestly, if somebody decides they really want to make trouble for you, they're going to say, okay, well, if one of you was living somewhere else, show me your cancel checks for the rent you paid, the
right.
utilities.
Right.
Oh, you live with your mom? Okay, well, she's ready to give a deposition. She's going to swear under oath that you live with her. You know, it's a felony if you swear under oath that you know it's not true.
Exactly.
I'll talk to the neighbors. Did he actually park his car there every night? So just, you know, what a tangled web we weave when first we practice to deceive. Let's, please, just anybody contemplating, just try to get that divorce. Live separate and apart. File that petition right away. Live separate and apart. You know, and don't run the risk of later on maybe somebody else who's not the spouse, maybe an angry ex-boyfriend or girlfriend wants to make trouble for you. Just don't go down that road, right?
That is correct.
Okay.
In all your cases
right.
and dealing with the court, you should tell the truth.
On that note, you can certainly live separate and apart. You can file the lawsuit at the beginning to get divorced. You can file it after you've lived separate and apart that period of time. What are some of the considerations, and we're running short on time, but some of the considerations to file the lawsuit for divorce early, at the beginning, and then live separate apart versus at the end?
It's less complicated to live apart and file it, and less expensive. But if you have a spouse that is running up debt, you have a whole year for that time period for that spouse to run up debt, as we talked about in the main session, that community property, you're liable for the debt if it's incurred during the marriage. So if you have someone who has gambling or credit card issues, go ahead and file before you live apart, because that way you are protected. Because when you file, if you finalize a divorce at the end of the year, the cutoff period for your liability to the debts comes back to the date you filed.
Very important point. In other words, it's the date you filed the divorce petition not the date, the judgment that follows the divorce petition that determines when the community property regime ended. And so if you're worried about the spouse going out and doing something stupid, you know what, even a car accident, God forbid, that someone might sue personally beyond insurance, that can render both spouses liable. So if you're worried about one spouse getting into trouble, running up debts, causing grief, maybe because he or she is vindictive.
Right.
You know, if you're going to take my stuff, I'm just going to go start spending it and getting rid of it. Have your lawyer file it right away, and then wait that time period to run, and then go back and confirm the judgment of divorce.
That is correct.
Okay. Last thing, we'll just take another minute or two. What happens with the time periods? What happens with what we've been talking about when domestic abuse is involved of either the spouse or children in the home?
If you have allegations of abuse, the 365 days will not apply. You can get a divorce quicker, just like you could with the adultery or the felony. But there are certain specific things that have to fall through. What happens is they feel like, do not prolong a situation that's not good. And it's either abuse allegations against the spouse or the child, and you have to have a protective order to use this.
Right. In other words, the court's going to step in and say, if the child is in danger, or if a spouse is in danger of physical, mental, emotional abuse, and the court believes that it's a legitimate concern, they will separate you and they will take steps to expedite the divorce.
That is correct. You don't have the same time periods to wait.
And there are resources available for people without money to get help in these situations.
Exactly.
And we'll see if we can get information on that on our website as well. Well, we are all out of time for this web-only webcast regarding John Redmann, Power of Attorney. Stacey, you've been so informative. We look forward to having you back on our show, back on our webcast, and we look forward to continuing the discussion. Thank you again.
Thank you, John. I'm glad to be here.
Thanks for being with us on John Redmann, Power of Attorney. See you very soon.